It's Entertainment Law Update, episode 180. Hard to believe, 180 of these. Here we are on May 28th, 2025. And here we go. Hi, everybody, and welcome to another episode of Entertainment Law Update from Los Angeles, California. I am Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamara Bennett.
And we are so glad that you are joining us for this episode. This is our podcast by entertainment lawyers about entertainment law, where each month we take the time to round up the notable cases, news, and information, keep you informed, and hopefully a little bit entertained. We love feedback from our audience, so please, if you have suggestions or input or telling us we're wrong about something, send us a voice note. You can go to entertainmentlawupdate.com and use the little widget on the side of the screen, or just send us an email. It's entertainmentlawupdate@gmail.com. Tamara, how are things?
Things are good. We just had a nice long Memorial Day weekend with really great friends. Attended a out of town wedding and just had a fun weekend. How about you?
I enjoyed downtime, not having to do. Actually, we had a busy weekend. We decided it was time to buy a new mattress, and
oh my gosh.
I have to say, I saw the coolest. They have a smart bed mattress now that measures every activators everywhere, and just you shouldn't need an app to run your bed. But
I know.
It was pretty cool. We did not buy the smart bed, but it's an investment in our health and comfort. So anyway, That was that. And then I went over to my mom's and did the Memorial Day grilling thing and had a nice time. Good to see everybody. So
fun. Yeah. That sounds great. Yeah. Good.
Yeah. Well, we have a big rundown, so I say we just jump right in and get started with the stories for the month. We'll start off with a kind of an anomalous thing happening in the Supreme Court. 5 justices recused themselves in the case of Baker versus Coates, and they had to recuse themselves. Here's the situation. There's a case involving a copyright infringement coming from the Second Circuit, having the accused infringement where the plaintiff was suing the parent company of Penguin House Bertelsmann. Notably, Penguin House is the publisher of books authored by 5 of the Supreme Court justices. So those justices all recused themselves, leaving the court without a quorum, and thus the lower court's decision that there had been no infringement nor any commonality with the topics covered. Anyway, so a non-infringement ruling stands because the justices recused themselves. So nice to see that they're doing what they're supposed to do under those new ethics rules.
Maybe somebody else can confirm it. I think I saw that there's been 3 cases maybe where they've not been able to take it because of recusals.
In history, I think, right?
Oh, in history. Yeah. Okay.
Yeah.
Okay. Because so many had to recuse themselves.
Yeah. So this has not happened much. And anyway, it's sort of just an interesting wrinkle in the.
Well, it's interesting for us because it also deals with copyright.
Yeah.
So
it wouldn't have been on our radar, but for that. So anyway,
so
sticking around the DC environs anyway. Let's talk about this Isaac Hayes case.
Yeah, so Isaac Hayes' lawsuit was filed in the U.S. District Court in Georgia by Hayes Enterprises, the company representing the estate of legendary soul singer Isaac Hayes. We've talked about this a couple of times in the past. It's a suit against Donald Trump and his presidential campaign around the alleged unauthorized use of the song "Hold On, I'm Coming" at political rallies. This suit really does raise significant and interesting issues regarding copyright law, trademark law, rights of publicity in the context of political events, and the limits that may be imposed in the blanket public performance music licensing that's available. So then Mr. Trump, I guess he now President
Mm-hmm.
Trump, began using Hold On, I'm Coming, co-written by Isaac Hayes and David Porter at rallies in 2020 under a blanket license in place at that time with Broadcast Music Inc., BMI, that generally permitted the use of every song in the catalog at any public event as long as it was licensed. But then BMI, as well as the other public performance rights organizations, started to allow their members to opt out of political licensing. And that's what the Hayes estate and his co-writer Porter did, formally withdrawing their song from the political licensing scheme. But Trump continued to use the song, triggering the copyright infringement claim. And separately, and very even more interesting to me, is the fact that this case also centered around the proper execution of termination rights
Yeah.
by the estate under Section 17 USC, Section 203, to reclaim the portion related to Isaac Hayes, to reclaim the copyright in the song from his publisher, Warner Chappell. And whether or not those rights did, who they reverted
Yeah.
to, who had the ability to exercise those rights in relationship to this lawsuit. So the estate originally asserted three main legal claims against Trump, which was copyright infringement, false endorsement under the Lanham Act, and then Tamara's just going to put in parentheses because we don't have a Federal Right of Publicity Act, and that's the closest thing to it, and violation of right of publicity law under Georgia state law. And there was a claim brought against a youth organization for hosting some of the events. And the court looked at the false endorsement argument under the Lanham Act, saying that Trump's playing of the song created the false impression that Isaac Hayes or his estate endorsed Donald Trump. They claimed to hold a trademark in Hayes's name and argued the use of the composition in a political setting without permission would mislead the public into assuming its affiliation or endorsement. And the court rejected that argument, calling it, quote, senseless. And I will tell you, I always include that argument in there. The estate never alleged that Trump or his campaign used Hayes' name or likeness, only the musical composition, which I'm going to add in this case was insufficient to support a false endorsement claim.
Yeah.
I think there could be situations where it could support it, but that's just Judge Tamara.
Right.
The court said that this would be a dangerous precedent, allowing any artist to sue over a properly licensed public performance, undermining the utility of blanket licenses. The mere use of a song, even at repeated public events, does not plausibly imply endorsement without further association or explicit approval. The court also went on to dismiss the right of publicity claim under Georgia law. Again, because Trump never used Hayes' name or image, the claim failed. But then let's talk about sorry, this is where I do have my pages messed up. The copyright infringement claim, only because I had extra stuff to say today. And the court said they can proceed on their copyright infringement claim. But it was really interesting because the defense raised a couple of issues that I think if you're interested in how copyright notices of termination work, this was a good case to go take a read, because the court walked through what you need to do to properly execute termination rights, that they had a majority, the widow plus one child qualified. So I think that was just a good read. They also made an interesting claim, I guess, that Hayes Enterprises was an improper party. So once the rights were terminated and reclaimed from Warner Chappell, they vested in the appropriate statutory heirs under the Copyright Act, and then those rights were assigned into Hayes Enterprises, an entity. It's unclear if there was a written assignment or not. And that's what the defense was kind of hanging on.
Yeah.
And the court said under 17 USC 204A, which requires the assignment to be in assigned writing, You know what? This is not for a third party to challenge that. That's only between the assignee and the
Oh,
assignor.
yeah.
Oh, I know. I thought that was so, at least for purposes of this portion of the proceeding, the court said ownership was sufficiently alleged
Yeah.
to proceed. So the court dismissed the false endorsement, publicity rights, and the briefly mentioned
Mhm.
third party liability claims. But again, it should be taking the next steps in litigation and possibly proceeding to trial as to the copyright infringement claim because the public performance rights were not licensed under the blanket license. So I
Yeah,
think yeah.
a little bit of a roadmap for future cases of this sort if they persist, and I'm sure they will. so,
Yeah, right, right.
um, so good. All right. Well, we have several quick cases dealing with photo copyright, and we thought we'd run through those sort of quickly. They picture three different photographers, each wake up one morning to find their work wandering the internet without them. Their journeys through the courts illustrate the three main hurdles that creators now face: timing, access, and fair use defenses. So the first one is a discovery rule case, basically. Michael Greco versus Ruthie Davis centers on a copyright infringement claim that raises a pivotal legal question: when does the statute of limitations begin to run? Greco alleges that the designer, Ruthie Davis, and her company RA Designs used his copyrighted photos of a model named Amber Rose from 2017 without his permission. Davis posted the images on her website and social media, but Greco didn't sue until 2021, 4 years later, prompting a debate over whether that claim is time barred. So the key issue here is whether the claims accrue when the infringement occurs, which is the injury rule, or when the plaintiff discovers it, the discovery rule. Davis argues the Copyright Act contains no support for the discovery rule and urges the court to adopt the injury rule. Greco defends on the basis of the discovery rule, citing its necessity in an age of hidden digital infringement. Interesting argument. District Court dismissed the case as untimely, finding that Greco, being an experienced photographer with a prior history of litigation, should have discovered the infringement sooner. But the Second Circuit reversed, saying, no, the discovery rule applies equally to all plaintiffs regardless of sophistication. And it's a binding precedent unless it's overturned by Congress or the Supreme Court. So in January, Davis petitioned the Supreme Court to resolve the split over these accrual of the case rules and to reject the discovery rule. Greco opposed, and the court has now acknowledged this issue in that Neely case, the Warner Chappell versus Neely from last year, but they left it unresolved. And so if the court takes the case and hears it next term, then we may get an answer on this for once and for all. We'll see.
I mean, I just feel like it has to be the discovery rule.
Yeah, I think the argument about the possibility of these hidden digital infringements going unnoticed for years and years, we have to do something to sort of address that. If there's no recourse just because it remained hidden, then it just doesn't seem right.
Yeah.
So,
Okay.
yeah.
Well, we'll see. Well, okay. Well, let's talk about Woodland v. Hill. In this case, where the plaintiff photographer failed to allege sufficient access on basis of his postings on Instagram. Freelance artist Rodney Woodland sued Montero Lamar Hall, aka Little Nas X, for copyright infringement, alleging that Hill, I think I said Hill priorly, alleging that Hill posted photos on Instagram that unlawfully copied Woodland's original photographs. Woodland, the plaintiff, posted these photographs between 2018 and 2021. They received minimal engagement. Sounds like my Instagram page. But I'm not posting what he was posting. But between 8 and 75 likes. While Hill's allegedly similar post, again, Lil Nas X, rapper, country, I'm not going to qualify him as a country singer. Anyway, similar post in 2021, attracted massive attention. The subject matter of these photographs were African-American men with no clothes on, with something covering their parts. So at first, I thought Little Nas X reposted the exact picture of this gentleman. No, he didn't post his picture, it's just two people posing naked. Anyway, so there we go. Woodland claimed Hill appropriated the original expression in his photos, asserting claims of copyright infringement, requesting declaratory relief, accounting, and unjust enrichment. The U.S. District Court for the Central District of California dismissed the suit, finding Woodland failed to plausibly allege that Hill had access to his photos, one, or that the images were substantially similar in protected expression. Woodland was given the opportunity to amend his filings but failed to state a viable claim. The Ninth Circuit affirmed the dismissal. The appellate court ruled that simply posting photos on a public Instagram account with limited engagement does not establish a reasonable possibility of access, especially when there was no tagging or dissemination directly to Hill. The court emphasized that copyright law protects only the selection and arrangement of creative elements, not general ideas or poses. Applying the extrinsic test for substantial similarity, the court found the photos lacked legally protectable similarities. They cited Feist Publications versus Rural Telephone, the Supreme Court decision that reiterated that copyright does not extend to unoriginal or general content. Because Woodland could not show either access or substantial similarity, the court upheld the dismissal of all claims, concluding there was no copyright infringement under the law. And again, these are two different people in different photographs posing.
Yeah.
And they just said no access. And even, I guess, even if there was just no substantial similarity.
Well, that access thing is the thing that caught my eye right off the bat. And I would think, now, how was this disposed of? Was this after a trial? It must have been an early motion, right? It was a dismissal. So it seems to me that there might be a way to prove through forensic computer technology logs, evidence, those kinds of things, that Lil Nas X's account did in fact see those images for access purposes. So it seems, I mean, maybe there was no briefing on that issue or I don't know, but seems like that might have been a jury question, the access part of it. So but if you don't get to substantial similarity, then it doesn't make a difference. So kind of interesting for a district court. Well, I don't know. The judicial economy matters too. So
yeah.
Well, the third of these photo cases is a Second Circuit saying that the trial court misunderstood fair use. The case is Romanova versus Amelis, Inc., coming out of the Second Circuit. Professional photographer Jana Romanova sued Amelis Inc., an online publisher, for willful copyright infringement after they allegedly published one of her photos without permission, credit, or payment. They failed to respond to the lawsuit, so she moves for a default judgment. And instead of granting the default, the district court raised the fair use defense on its own, a sua sponte fair use defense.
That's exciting, maybe. I don't know. And that's weird.
Yeah, for the court to bring up an affirmative defense, So anyway, they asked Romanova to justify why the use wasn't fair, and then eventually dismissed the complaint with prejudice, concluding that it was a fair use and reasoning that it conveyed a different message and therefore qualified as transformative use under the fair use doctrine. They said defendant's article showed 10 photographs of people with pets. The article declared that it was published in continuation of the website's semi-regular series focusing on the ever-increasing amount of pet photography we find online. So she appeals, and the Second Circuit reversed, saying the appellate court found the district court had both procedurally and substantively erred. First, it ruled that the fair use defense is an affirmative defense that must be raised and proved by the defendant, not the court, especially in a case of default. And the court found that the use was not transformative. It republished the photo without alteration, commentary, or new purpose, and said the test for transformativeness turns on whether the copying of the original communicates a message that differs from the message of the original, not whether the copier separately declares such a message. So because it lacked transformative character and valid justification, it failed on the first and critical prong of the fair use test. So They said she's entitled to the default judgment on her unchallenged claims and remanded the case with instructions to enter that judgment in her favor. And there's a key quote: fair use cannot be conjured up by a court to excuse a defaulting party's infringement.
So could the appellate court, because then why does the appellate court get to make an opinion about transformative? If they're going to say, district court, you didn't have the authority to do this, why didn't they just stop there instead of giving their own opinion on why it wasn't fair use?
Well, that is an interesting question, isn't it? I mean, I guess if the...
I mean, it sounds kind of like you can't do it, but we can.
A little, yeah. On the other hand, they are allowed to correct a misstatement of the law of, what is transformativeness, I think. So they were addressing probably something that the trial judge expressed as how the rule operates or something.
Okay.
So, but you're right. I mean, I think the response that would be appropriate is, we think you got that wrong, put it to the jury. Not, you got it wrong, here's why. And too bad you're dealing with it. So we'll see. Yeah. But in a default judgment situation, there is no jury. It's never going to go there. The findings of fact all go in favor of the plaintiff, and that's the procedural point they were making. So, so the commentary on this is, with digital platforms making infringement easy and discovery random, and proof is complicated. So here are these cases that show you got 3 gates to get through to bring a case. First off, if the court sides with the Supreme Court sides with Davis on that case, the clock ticking from the day the photo is first infringed, that may be a thing. So you got to get the timing filed on time. You've got to actually show there was access, the opportunity to make the copy, and then relying on fair use is risky in the best of cases. So, but it's a defense, not a sua sponte thing.
not for the judge to say, "Hey, what about this?"
Anyway, so let's move on. We have another case over. The ruling is the jury should be just the ones to decide about similarity. So let's talk about Dancing with a Stranger.
Yeah, so a new development in the case involving Sam Smith's hit song and Dancing with a Stranger. Just last month, the Ninth Circuit Court of Appeals reversed a summary judgment that was awarded in favor of Smith back in 2023. In 2015, Jordan Vincent and Christopher Myrand co-wrote and released a song entitled Dancing with Strangers. Their music publisher and party to this case is Sound and Color LLC. And in 2019, Sam Smith wrote and as the artist released a song that was also entitled Dancing with Strangers. There were also other songwriters, co-writers. Sound and Color's copyright infringement claims are based on their allegations that the Smiths song copied their lyrics, key, pitch sequence, melodic contour, rhythm, and metric placement, chord progressions, and other musical elements. In 2023, Smith and the other defendants, the other co-writers, brought a motion for summary judgment to have the case dismissed on the basis that there's no substantial similarity between their song's chorus and melody versus the 2015 song owned by the plaintiffs. In asserting the summary judgment motion, the district court zoned in on using the extrinsic test to determine whether there was substantial similarity in musical elements between the two songs. So when the court uses the extrinsic test, they rely on expert reports and testimony of many experts that break down the two songs to determine any similarities in musical elements. In the Smith case, several experts testified regarding the similar lyrics, quote, Dancing with a Stranger, and compared the two songs in terms of the musical elements, key, pitch sequence, melodic contour, rhythmic, and metric placement, as well as chord progressions. Sound and Color's main claim is that the musical elements in their 2015 song are not protected by copyright individually as individual components, but rather based on their original selection and arrangement of all of these elements that make the melodic phrase. They're asserting that Smith and his co-writer's melodic phrase is substantially similar to the arrangement in their melodic phrase. The court also addressed the lyric issues, basically stated that the phrasing, dancing with a stranger, is unprotectable under copyright law because it's in so many different musical works. They looked at the musical elements, again, determining all these different things related to pitch, rhythm, so on and so forth. And when it came to the plaintiff's claim that its selection and arrangement of these elements has copyright protection, the district court decided that the musical elements in Sam Smith's melodic phrase did not, quote, share in substantial amounts the same arrangement as that from the Sound and Color song. So Smith succeeded in his summary motion judgment. On appeal, the Court of Appeals made a decision just a few weeks ago that a jury would actually likely find there is a substantial similarity in the selection and arrangement of musical elements in both songs. Interesting, not as to the lyric, but as the musical elements. Sam Smith and other defendants tried to argue that the Sound and Color song had only thin copyright protection, which would raise the bar, and they would have to prove that the songs are identical. I don't think that's the standard. Sam Smith arguments failed in this case, and instead the appeals court decided that the hook, so that chorus, in Sound and Color song was uniquely selected and arranged, and thus may be protectable. So it's moving forward, going down that road toward a jury trial, which we'll be following and we'll be updating. Who knows if it'll settle or what will happen on that. So
Yeah.
lots of great music copyright cases we've got going on.
Yeah, it's been an interesting month for that. And keeping things interesting, did you know there was a restatement of copyright in the works?
Okay, I did not. So let me tell you what I remember from law school.
Yeah.
The restatement is just a restatement. It is not the authority.
Correct.
Because I always remember, restatement of torts. That always, so much of law school seemed to be surrounding Prosser and the restatement of torts, but yet, it wasn't the end all to be all.
Secondary source.
It's a secondary source. That's right. So what's happening around the restatement of copyright?
Well, there's been this move toward a restatement going on for, I think, about 10, maybe a little longer than 10 years. And several copyright experts, Professor Jane Ginsburg and Shyam Balganesh of Columbia Law School, Professor Peter Manel of UC Berkeley School of Law, and attorney David Nimmer from Arell and Manila, they have formally disassociated themselves from the ALI, the American Law Institute's restatement of the copyright law. On May 12th, they sent a letter to ALI members urging the council to veto the draft restatement when it came up for a vote, arguing that the project's unprecedented move to restate a comprehensive federal statute without treating the act itself as the black letter baseline is a threat to the Institute's scholarly credibility. Their core objection is to the methodology. The restatement has proceeded, they say, without adequate peer review or substantive feedback from these advisors, including calls to preserve robust fair use protections. That's been sidelined. They warn that the draft's paraphrasing of statutory text risks creating a shadow statute that diverges from what Congress enacted and confuses rather than clarifies the law for lawyers and courts. Signatories to this letter contend that this isn't merely an academic quibble about but it's actually a fundamental breach of the restatement's mission to synthesize, not to supplant, existing law. So the ALI Council will decide on this, and if they heed the plea, then the vote could be delayed or defeated, and that would be a rare rebuke of the project at the 11th hour. But even if the restatement survives, there's a lot of controversy. It's spotlighting the delicacy of balancing statutory strength against the desire to guide the judicial interpretation. Now, the background here is that the people who were driving the move toward the restatement in the first place are information wants to be free types, I guess you could say, the more libertarian approach to ownership of intellectual property, and in particular connected with the tech industry, which of course with the AI and other things, there are some interests there that these folks feel are being disproportionately represented in the way the restatement is being crafted so as to maybe undermine thoughts about fair use and where the boundaries for infringement lie and things. So politics at the ALI, I guess you could say. It's economic politics, really.
And we've got the whole Nimmer treatise.
Right.
Do we need a restatement?
Yeah, when you think about it, the treatise is the restatement in a sense. So, yeah. So,
right, as well as other excellent sources.
Sure. Yeah. But it does make you think about, here are these things that in law school we learned, or you could sort of rely on them. And, to see, now that we're seeing how the sausage is made, so to speak, we're maybe not as thrilled about eating it or consuming it. So.
Well, and so what I don't know, because it's been a long time since I've been in law school. How old are you? I always think of the restatement relating to common law, not statutory law. Am I wrong on that? The restatement of contracts, the restatement of torts.
Well, I think there's probably, property. Well, that also goes back to common law, but there have been some modifications. Yeah. So, anyway, it'd be interesting to see what happens with the vote of the committee and what's next. But it sort of just took me by surprise that there even was going to be a restatement of copyright, and that I never would have thought that it would be something that would be sort of influenced by external biases. And exactly. So something to pay attention to when you're reading, when you're doing research is, you have to look at the source a little more carefully than we thought, I guess.
Yeah. Law students, don't forget the restatement is a secondary source. So, and
created by people who have opinions and points of view that may or may not be completely in line with the actual law. So that's,
interesting.
Yeah. So mixed feelings about this next revenge porn law. The president signed into law on May 19th. He signed the Take It Down Act. This is the first federal legislation in the U.S. specifically targeting distribution of non-consensual intimate images, including AI-generated deepfake pornography. Sounds great. Sounds like the right thing. And in fact, the way it was a sort of bipartisan bill. So the key provisions here are it makes non-consensual content published criminal. The act makes it a federal crime to publish or distribute sexually explicit images or videos of individuals without their consent. And that covers both real and AI generated content. I have a little bit of a point to make there in a second. But also it puts on the social media platforms and websites a mandate that they need to remove the content, this kind of content, within 48 hours of a victim's request. The penalties are up to 2 years in prison for publishing adult content and 3 years if the content involves minors. And the FTC will be tasked with enforcing the law and using its authority over deceptive trade practices. So the First Lady played a big role in advocating for the bill, aligning it with one of her initiatives on youth well-being and online safety. And she was lobbying and made a lot of public appearances to garner support. And it did receive bipartisan support in the Congress, passing the House 409-2. And the Senate was unanimous. Companies like Meta, TikTok, and Snapchat endorsed the legislation, recognizing the need for clearer guidelines in handling non-consensual explicit content. But there are some digital rights organizations that have expressed concerns about the overreach and suppression of lawful speech. So critics argue that the law's language might be vague and could lead to unintended consequences like removal of legitimate content or challenges to privacy tools like encryption. So also apprehensions about the use, the potential for misuse of the law for politics purposes, especially given the current administration and its relationship with certain agencies and things like that. So significant step forward in addressing some challenges that have come up in this last few decades, and especially with AI. But it's trying to protect privacy and dignity, but it also poses risks for free speech and things like that. So the point I wanted to make was that the case of Ashcroft versus Free Speech Coalition ruled the child Pornography Protection Act unconstitutional as applied to fake child pornography, where they weren't really kids or it wasn't a real person at all, like cartoons and things like that. Seems to me that AI-generated deepfake can look to a law like that and say, well, it doesn't apply to us either. Although if it looks like a real person. So I just, I do worry.
It's hard.
Yeah.
It's hard because I think we as humans, we as having children,
Sure.
the last thing we want is someone we love to be a victim of something horrible like this. So I went back and I just didn't remember Ashcroft, everything about it. And so I perused it quickly. It was from 2002, hard to believe. It's been over 20 years ago. And I thought it was interesting. Rehnquist dissented. That maybe wasn't interesting, but he dissented. And he said in 2002, this is a rapid technology. And I'm summarizing, we're going to get to the point where we can't distinguish between real versus fake. And I think in 2002, it was easier to distinguish. Now, it wouldn't be easier to distinguish between a real person who was over 18 who was pretending to be under 18, but the wrong person's head attached to the wrong body. Maybe in 2002 that was not as much of an issue as it is today. So I did not have an opportunity to look to see if any claims have been brought yet. And I guess is it a personal claim? I mean, if you can file a takedown notice, I guess it is.
Well, yeah. And I mean, it's only been in, 10 days.
Effect. Yeah. I mean,
so
I know Texas, when I was at the Texas Capitol earlier this year advocating, we had a pending AI deepfake bill on the books, and it looks like it passed one side, but never got to the other side. So a lot of states as well are trying to enter the fray to protect their citizens.
And that may raise questions about federalism and
preemption
and all those kinds of things. So I think we're at the beginning. And look, positive that the Congress was almost unanimous and the technology industry mostly got on board. But, I think I do worry about a victim just being able to say, hey, take it down in a la DMCA if there isn't a guardrail and a responsive way of addressing it to say, wait a minute, you're wrong here, something like that.
Right. And like the DMCA, how long is it? There's going to have to be some kind of response and procedures, and I don't know when all that has to be implemented by.
Right. So it'll be interesting to watch, and I think it's overall a positive, but I do worry about folks getting caught up in either false accusations of this stuff or expressive content that isn't a particular person, for example, being taken down in sort of an abridgment of free expression rights and things like that too. So we'll have to watch what happens. I'm sure it'll be years and years ahead from now. We'll still be seeing challenges to this kind of, if it remains in effect. But now that is a great transition into our AI corner, where we have a fairly large bit to talk about. First off, a sort of striking comment from the bench in the case against Meta. This is Kadri versus Meta. That's the case brought by authors Sarah Silverman and Richard Kadri and others. It's a closely watched infringement case, and the judge in the case is Vince Chabria, who expressed pointed criticism over a claim by Meta that using copyrighted books to train its large language model, Llama, AI tool qualifies as fair use. During a hearing, the judge interrupted Meta's legal team to say, I just don't understand how that can be fair use.
Sorry. I love it.
You don't hear about judges saying things like that quite as blatant as directly. So he elaborated. He questioned Meta how Meta can claim fair use on an AI system that is, quote, capable of spitting out an infinite number of works that are going to compete with the original works, yet provide zero compensation to the authors. And he warned that this kind of a model could obliterate the market for the original works, highlighting a key factor courts have to consider in fair use, that fourth element, right? Fourth factor. His comments suggest a deep concern that the AI-generated outputs could replace human-created works in the marketplace, and that calling that fair use might be legally untenable. So, no ruling yet. He indicated the outcome might hinge on whether the plaintiffs can prove actual market harm from the AI training and output. But this rare kind of candor on the bench gives authors, creators, and AI companies a preview of how the courts may be looking at some of these cases as they move through, and maybe some doubt on the breadth of the fair use defense in these cases. So we'll be watching, but it could be a turning point. So we'll see what happens there. Yeah. What about the Copyright Office report? By now, everybody's heard
all right.
this.
So that's been a lot going on. The Copyright Office report in pre-publication part 3 on generative AI training was released, feels 2 weeks ago, maybe.
Yeah.
We've got last week here, but I think it was 2 weeks ago, middle of May. The U.S. Copyright Office released a pre-publication version of part 3 of its report on, quote, copyright and artificial intelligence, focusing on the use of copyrighted materials and what we just talked about, training generative AI systems. It's a 108-page document. I have not read all 108 pages. But I think I will, because these reports are so detailed and comprehensive, but on related to AI training, fair use, it gives us nuanced insights into how existing copyright laws apply to emerging technologies. It actually takes a firm stance against the owners and operators of AI platforms. The Copyright Office focused on fair use. The office deems that training may be a highly transformative use. Okay. But that is tempered by what the AI algorithm is being trained to provide as output. The algorithms are trained to produce similar material to copyrighted works, disfavored. Trained to help with moderation, finding and blocking profanity, say, in a document you're looking at. That use could be more favored. The office has adopted the theory that AI poses a real market harm, which is what we just heard the judge speaking about, both for licensing works for training and for creating substitutes. As to the factor of the amount and substantiality of the work, kind of a toss-up, the document said. The nature of the works copied, especially as it pertains to more expressive works, disfavors the finding of fair use. So that's interesting. So if AI trained on news articles, encyclopedia entries, those kinds of things are less protected, even though I think Encyclopedia Britannica might disagree. But what about the impact on the market? That's usually factor 4 in the analysis on fair use. And it's saying that's a major focus, though it is based on more speculative measures, i.e. dilution due to the creation of art or lost licenses. Is there going to be market dilution? I don't know. Is AI going to flood the market that could harm potential market for original works, even if there's not direct copying? I think that's where the controversy is kind of lying, is in this market dilution theory. The report also argues that AI should not be compared to human learning, and that AI is capable of perfectly replicating any content it learns. So it is the machine.
Skynet is watching. So the report sounds to me like it's saying, look, we can't separate out the ingestion of the data, the training from the outputs, that it's all one big infringement we have to look, or one integrated infringement we have to look at, because the nature of the outputs and that market dilution and how similar is the output to the original work, those are really factors that have to be considered. So I think it sounds like the office is saying we can't just look at the training. It's more than that. Is that right?
And of course, I think so. And of course, the defendants in these cases are saying, well, all we've done is train.
Yeah. Yeah.
We can't control how someone might use this. Oh, are we going to have a videotape case here just because we create the Betamax? I mean, we created the machine. That doesn't mean we're responsible.
And maybe there comes into questions the nature of the design of the machine itself. Did we train the machine to copy, or did we train it to adapt and transform?
They're training the machine to copy.
Well, it depends who you ask, right? So, interesting. Well, this is, you're damned if you do, you're damned if you don't. And, Congress says, hey, Copyright Office, give us a report.
Give us a report. we need, Register of Copyrights who serves at our pleasure, segue. Yeah. Give us a report on what you think, you smart people over there.
So they do the report. Interesting that it was published as a preliminary draft rather than just saying, here it is. I don't know what's going on there. And I wasn't able to find much about it. But I think
we all know what was going on there. Yeah, but anyway, go ahead.
Right on the heels of this report coming out, the president fires Shira Perlmutter, the Register of Copyrights. No specific reason given.
Also, to back up, sorry, just to interrupt. Also, as well, the Librarian of Congress was fired, and the position, I believe, of Librarian of Congress is the one who has the authority to appoint the Register of Copyrights. Right. But both received an email saying, "See ya." I'm sorry. Go ahead.
And since we're on it, the Librarian of Congress role, the White House did come out stating reasons for the firing, including that they had chosen DEI and other inappropriate books to include in the library for children. And anybody who's been to the Library of Congress knows this is not a child-friendly library, and it is a what's the word? An archive, not a lending library. So. Anyway, so that was a little preposterous in the reasoning there, but ultimately no reason given for why Perlmutter was fired. The timing of the report, of course, has to be the nexus there, this unfavorable stance toward the AI company, point of view on fair use in training and so on. So broader tensions between tech and the intellectual property community. And, just to note, the president and his connections in particular to Musk, but also other tech folks, definitely viewed as a probable motivation here. So Perlmutter has filed suit against the White House for this termination, arguing Congress made this law, Congress made this office, Congress appoints, and the president doesn't have the power to fire the director of the Copyright Office. It's a position under the Library of Congress, and that's a legislative body. And so, we'll see. It's going to be a while, but it's troubling, I think, to see what has again. Restatement of copyright. Never really thought much about it. Never really thought much about the partisan politics affecting the Copyright Office and the Library of Congress. It just doesn't seem like these are partisan agencies.
So I found this somewhat fascinating and went down a lot of, I don't even know if they were rabbit trails, but just kind of more related to the appointment of the Librarian of Congress. Yeah. Prior to the last 20, 30 years, it was a very political post.
Is that right?
And I had no idea. Yeah. And oftentimes it wasn't a librarian. Mm-hmm. So with the Librarian of Congress, who was just fired, not only was she a library science educated person, she was I believe the first female, and I know she was the first person of color to serve in that role. But I had no idea that was a political appointment.
Me neither.
Never thought about it, but it clearly, now we know, and if you go back and look through history, it was. So
political or just sort of patronage? Let's just find a job for somebody.
Maybe that's the better term.
Mm-hmm. Okay. Well,
maybe that's a better term.
Interesting.
Again, Tamara's opinions, nobody else's opinion, just my opinion.
Well, it's not just the U.S. that has to deal with these political questions and fights over how to regulate these things. In the UK, there's a big brouhaha going over the government's move to set up some what's the word I'm looking for? Some AI regulation. Hundreds of leading figures from the UK's creative sectors, Paul McCartney, Dua Lipa, Ian McKellen, the Royal Shakespeare Company, they have penned an open letter to the Prime Minister, Keir Starmer, warning that the bill, the Data Use and Access Bill's proposed copyright exception for commercial AI training, threatens the very lifeblood of their professions. And the draft legislation would allow AI developers to ingest protected works unless creators explicitly opt out, effectively shifting the burden onto the rights holders to police usage. So opt out, not opt in. Okay. So opposition's opponent to the bill urged the parliament to back an amendment requiring AI firms to disclose what works they've used and to negotiate fair licensing terms, rather than a free-for-all model that's just the default that endangers the UK as a place for creativity. So the critics, of course, say the opt-out proposal forces creators to rent back their work on unfavorable terms, and they want a transparent framework that this disclosure and so on. As of May 20th, the House of Lords rejected. So the House of Commons passed it. The House of Lords has attached an amendment that would mandate the disclosure of what materials were used in the training. And so now the bill goes back to the Commons, where the debate continues. And I don't know exactly how they arrive at a final answer in these things, but should we?
They yell at each other a lot, right?
Yes. Well, that's the theater.
Or is that just TV?
No, I think it's
okay.
That's
okay.
Yes, the theater of government is a whole other thing, I guess you could say. So, I think that's it for our rundown.
Yeah, there we go.
Sorry, I got distracted.
Maybe we should be more theatrical
on my screen. Yeah. So I thought we were going to go long, but we're actually a little shorter than most of our episodes. So I guess something went right.
That's okay. Yeah.
Well, listen, that does bring us to the end of this episode. And I want to say thank you to all of our loyal listeners for spending your time with us. We would love it if you got in touch, gave us feedback, just to tell us how we're doing. Are we doing a good job? Are we doing a lousy job? What would you improve? What would you like to see? Is there stories or topics we're not covering that you think we should? We'd love to hear from you. You can leave that for us using a voice widget over at entertainmentlawupdate.com, little red flag on the side of the screen. Or you can email us, entertainmentlawupdate@gmail.com, and find us on social media as well. Tamara, tell folks how to find you.
Yes, you can find me at my new firm, harperbates.com. You can also continue to find me at createprotect.com. That's where all of my historical information is housed. Social media on most sites at Tamara Bennett, TamerABennett. And I'm going to ask folks so that we can be in the category of having lots of clicks in the case we get infringed. Come, one, like us on wherever you listen to podcasts, but also go visit us on YouTube. Yeah. We're there live and in person. If you ever wondered what Gordon and I look like. Maybe not. Yeah. I don't know. Yeah, go check us out. How can people find us on YouTube, Gordon?
Type in the words Entertainment Law Update, or just you can search on my name. G Firemark is my handle on YouTube, and it's under my account.
Okay.
There. So it's a playlist called Entertainment Law Update. So
there you go. Yeah. We're there.
And from Los Angeles, I'm Gordon Firemark, and you can find my website at firemark.com. There's another one at gordonfiremark.com. Email address, gfiremark@firemark.com, and on most social media websites, gfiremark. And finally, let's say thank you to our team of volunteer contributors. John Janacek is our managing editor and put in a valiant effort this week. Charles Thorn, Alexis Allen, Violet Zhang, Tasha Spear, Dawson Holder, and Lelwa Maseti all contributed to this episode. And hey, if you are interested in joining the fun as part of our little family of contributors, reach out using that email address, entertainmentlawupdate@gmail.com, and let us know, and we'll try to get you into the team. So That's going to wrap up this episode of Entertainment Law Update. Thank you again for listening. I appreciate you. And until next time, that's Showbiz.